So without further delay, we will get started with the presentation. So let's talk about the National Interest Waiver requirements. This category is under the EB-2 category of a green card, which means there is a threshold requirement of either an advanced degree, meaning a master's or higher, or its equivalent. So that would be a U.S. bachelor's degree plus 5 years of post-baccalaureate progressive work experience in the profession. So that's just important to note that even if you have a bachelor's degree, you still need that 5 years of experience after you've earned that bachelor's degree. If you don't have a degree, the other way to qualify for the EB-2 is through a showing of exceptional ability. There is a two-part test to determine exceptional ability. USCIS will first evaluate whether the evidence meets the regulatory criteria. So for example, do you have you commanded a salary that demonstrates exceptional ability? So do you have evidence of meeting a high salary? And then they'll evaluate the quality of that evidence. So for another example, being a member of a professional association may satisfy, one criteria, but in the second part of the analysis, the officer will consider whether the membership indicates that the person has a degree of expertise significantly above that ordinarily encountered in the area of expertise, so the sciences, arts, or business. So once you've met these threshold requirements, then you have to show that you demonstrate that you qualify for a national interest waiver. And for a national interest waiver, you need to show that you are seeking to do a proposed endeavor that has substantial merit and national importance. They'll evaluate both. Show that you are well positioned to advance this proposed endeavor. And then also show that on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. So normally for the EB-2, you'd need to go through what's called the PERM process, where you have an employer and that employer tests the labor market to determine if there are any willing, qualified, and available US workers. When you're doing an NIW, you're asking for the government to waive that requirement, because of the substantial merit and national importance, and that you're well positioned to advance your endeavor, and that on balance, it's beneficial to the US to waive this requirement. So turning to kind of just an example of, a case where someone has met each of these criteria, we'll take the example of an engineer who was going to run a consulting firm based on technology management and workplace consulting. And this engineer had developed a patent to help small and mid-sized businesses automate and optimize profitability without losing jobs. So that ability to retrain and redefine a workforce and prevent US job loss. So when we look at substantial merit and national importance, preventing US job loss, providing companies with a way to stay competitive while not displacing workers, and hiring US workers were all very important to meeting this prong. For showing that the person was well positioned to advance the endeavor, this applicant had 30 to 40 years of experience in relevant jobs, had letters from former supervisors and colleagues, as well as people who are interested in partnering with this person's new business. So all of that was very important to show this person had a track record of success in this particular area, and also had industry experts, people in high-level positions interested in working with this person. Additionally, showing that on balance, it would be beneficial to the US. When somebody is an entrepreneur, one argument you can make is that it is impractical to get a labor certification because the person owns the company. So the labor certification process is set up such that if you are a majority owner of a company, it's really not set up, to allow for approval in that circumstance. You can also make the argument that the work that's being done is so important, that even if there are other people doing this work in the United States, it's still a sufficiently urgent issue to, warrant foregoing the labor certification and allowing this person to proceed with their endeavor. Perfect. So let's talk about how the National Interest Waiver can be used for entrepreneurs. So in the past few years, when the standard for National Interest Waivers changed, it became much more friendly to entrepreneurs in the case matter of Danazar, where there was some specific language that was added, that was just particularly helpful for entrepreneurs. So when we're talking about, substantial, national interest, and substantial merit, the benefit to the U.S. interest can be local. So if you're talking about, bringing, a benefit to the U.S. by hiring workers, you don't need to show that you're going to be hiring nationwide, particularly if you're in an area where there's an economically, depressed area where there's low hiring, kind of having your endeavor in that area and showing you'll be able to hire U.S. workers, can satisfy this prong of substantial merit and national importance. Another, point for entrepreneurs that's important is that because entrepreneurs are self-employed, they really are not eligible for green cards under the labor certification requirement. Any ownership has to be disclosed during that process. And if somebody is a majority owner, it's very unlikely, just really not possible that the government will determine that there's really a bona fide job opportunity open to a U.S. worker. So entrepreneurs can use this in the NIW process to show that it would be, impractical and essentially impossible for them to obtain a green card through the normal labor certification process. And with showing, the other elements of the endeavor, they can argue that on balance, it is beneficial to waive this requirement. DNSR also specifically notes that entrepreneurial work can lead to an NIW. And importantly, I think they state that you don't need to show that the planned venture is 100% going to succeed, as long as you can show that it is more likely than not to succeed. So, one thing that comes up sometimes, people ask whether entrepreneurs need an established company to qualify for an NIW. No, you don't. It can be helpful, but it is also possible to apply with a brand new startup company. As mentioned in the last bullet point here, Danazar did explicitly acknowledge that many entrepreneurial ventures may ultimately fail, and you don't need to prove that it's that it's 100% going to succeed, as long as you can show, in the evidence that the person is well positioned to advance the endeavor, and it's more likely than not, going to succeed. I think that another thing people sometimes ask is whether there's what are the pros and cons of going in with an established company versus a startup. So applying with an established company is helpful, if the company has a track record of success and job creation. However, it can cut both ways. So if you're applying with a company and the company is not doing well, I think you're going to have a harder time convincing them that you'll ultimately be successful in the long term. So for startups, one benefit you get is you do have, if you create a very compelling business plan, you have more ability to rely on those projections. It is in that case, I'd say that even if you're applying with a pure startup, the applicant themselves should ideally still have a track record of success with other similar ventures. So if you're starting up something new and you've never done such a thing before, that's going to be very, very difficult for the NIW. However, if you are, an entrepreneur, you've started many companies successfully, and this is your latest venture, that's something that can be used, I think, successfully for the NIW, focusing heavily on your track record of success with other entrepreneurial ventures, hopefully in a similar field. So it kind of makes sense in terms of your particular experience. All right, so let's talk about timing. So timing and other considerations when moving from a non-immigrant visa to an NIW. So there is no premium processing available for the National Interest Waiver at this time. What this means right now is that if you file an I-140 for the National Interest Waiver, it could be pending for several months, even up to and over a year. We do hope and expect that this will change pretty soon. There has been, have been regulatory changes that have indicated that premium processing for national interest waivers is going to be coming, and rather soon. So we are continuing to follow that. And I'd say, continue to, if you follow our blog, continue to look at our blog. We will, post announcements as we receive more information about that. So one thing to consider is what is your underlying visa status? So if you're in the United States on a non-immigrant visa that doesn't explicitly allow for dual intent, so a TN visa, an E visa, once you file an I-140, it's going to be more difficult to renew that visa, or even, not possible. So for a TN where there's extremely clear, it's extremely clear that you have to have non-immigrant intent and a foreign residence you don't intend to abandon. So renewing that once you filed your I-140 is going to be quite difficult. For the E category, it's more of a quasi dual intent category. So it may still be possible. There's an argument for, why that you may be able to continue to extend, but you wouldn't be able to travel in and out of the United States easily. So in terms of the application process, you're going to submit Form I-140 with proof that you meet all the EB-2 qualifications. So this includes that threshold requirement we talked about with the degree or proof of exceptional ability, and then all the documents that show that you meet the NIW criteria of substantial merit and national importance, that you're well positioned to advance your endeavor, and that on balance, it's beneficial to the US to waive the requirements of the labor certification. All of that goes with the I-140. If you're in the US in valid status and there is an immigrant visa available to you, you may also want to concurrently file your I-485 green card application. It's going to be very specific to every individual, whether or not they choose to do this. You may, there may be reasons why you choose not to file your I-485 yet. One in particular, let's say you're here on a TN visa and you submit an I-140 and an I-485 together, now you can't extend your TN visa, and you also couldn't travel internationally without abandoning your green card application in the United States. You'd have to wait until you received advance parole, the travel authorization that you could file with Form I-485, and then you could travel, but you wouldn't be on TN status anymore. You would just be paroled into the United States. And if for any reason your I-140 was ultimately denied, your green card application would also be denied. So there may be reasons why you don't want to file concurrently, even if you have the option to. In those cases, you may choose to file your I-140 and then, indicate you're going to consular process. So doing that would allow you to continue traveling freely on your underlying visa that you have. And then once the I-140 was approved, the approval would be sent to a US consulate, and you would go to that consulate to finish the green card process. So it's an important thing to discuss with your attorney. Is there kind of many, it's very specific to every individual, kind of what is right for them. And it's always important to kind of discuss all the pros and cons. So let's talk about some of those, the pros and cons of, adjusting status in the US versus consular processing. So, a pro to adjusting status is if you live here as you're working in the US and you have your family here, your spouse and your children, adjusting status in the US means you can all file your green card applications together. Everyone can apply for work and travel authorization at the same time. And you're able to stay in the United States. So some people really like or need that continuity for their children who are in school, or if they're working here, their spouse is also working here on a dependent visa. Adjusting status gives you that ability to remain in the United States while the application is pending, and also to apply for work and travel authorization for everybody, in your family unit who's applying for the green card. However, a con, as we discussed, is you cannot travel freely on your non-immigrant visa once you have filed your green card application. So the exceptions to that are if you have an H-1B visa or you have an L visa. Those are dual intent visas, and they also have special permissions that allow you to travel without travel authorization from USCIS when you have a green card petition pending. But those are, kind of the exceptions for many people. If you're on another type of visa, you would have to wait till you get that travel authorization permission from USCIS before you travel. And then when you do travel and you come back in, you're not coming back in on a visa, you're being paroled into the US. So your status is a bit more uncertain. For consular processing, the pro is that you're allowed to, if an I-140 is filed and you have an underlying visa, you pretty much, you can travel on that visa. There's not nothing's restricting you from traveling. But the con is that filing an I-140 doesn't give you any status in the United States on its own. So if you're here, for example, on a student visa and your student visa is ending, and you have an I-140 that's been filed, you're not going to be able to stay in the United States based on that I-140. You would need to leave and either get a new visa before you wanted to re-enter the US, or just wait outside the United States until your petition is approved and you can go to the consulate to get your green card. Okay. So what is included in an NIW submission? And this is kind of all the documents that go with the I-140 that we talked about earlier. So initial proof is going to be proof that you meet one of the threshold requirements. So that's a copy of your degree and transcripts. If you're, qualifying based on that bachelor's degree, you're going to need the degree and transcripts plus proof of prior work experience. So usually letters from former supervisors or HR professionals on company letterhead with contact information that provides the enough detail that they can see that this is post-baccalaureate progressive work experience in the relevant industry. If you're applying based on exceptional ability, then you'll need to show you meet at least 3 of the 7 criteria to qualify for exceptional ability. And then you have to include evidence that you qualify for the National Interest Waiver. So when we're talking about, not substantial merit and national importance, things such as news articles, academic papers, market research, data and statistics, a comprehensive business plan if you're an entrepreneur, and any other kind of objective evidence to demonstrate the substantial merit and national importance of your endeavor. So, very often, if you're in the sciences or civil technology, there's government reports that kind of outline a lot of things that are important to the government that they're focusing on, various initiatives. To the extent you can pull from those types of documents, of respected professionals in the field and both government and the private sector, that's going to be very helpful to kind of bolster your application. You can also include expert letters. These can be used to demonstrate substantial merit and national importance. They can also be used to show the applicant is well positioned to advance the endeavor. So you may have kind of a mix of different types of letters. It's always good to have letters from people that perhaps are not, don't know you closely, but perhaps are aware of your work. Or you may get a letter from an outside expert, such as an economist, speaking about kind of the economically depressed hiring in a particular area and kind of what's needed to help in that area. So things like that are very helpful, for applications. Kind of talking more about the letters, people ask, can I use an old recommendation letter for the NIW? Generally, no. Expert letters are really very different than recommendation letters, and they serve a very specific purpose for the NIW. So the letters really should be tailored to explain the substantial merit and national importance of the endeavor, or to explain the background of the applicant and kind of where their expertise comes in to show they're well positioned to advance the endeavor. In terms of what should be in the expert letters, they should really speak to the applicant's contributions to the field and the importance of the endeavor, if possible. The letter should contain a description of the expert's relationship to the applicant, a description of their professional history to show, why they are qualified to write this letter, a description of the applicant's professional history and any important contributions to the field, any prizes or awards that have been won, any influential publications, business successes that have happened, any participation in prestigious panels, any groundbreaking research, or any, like, let's say somebody has developed some type of software or system that's now being utilized at the highest levels of, government or the private sector. Those are all very helpful. And any background information the expert can provide on the field of endeavor and why it has substantial merit and national importance. Sometimes there are niche fields where really you need these experts to kind of demystify it for the officer who's not going to be an expert in this area. Other things that are included in the NIW submission will include kind of the applicant's resume, any proof of professional accomplishment. So anything that's mentioned in the letter should be backed up with objective evidence in this section. So if you discuss a patent, the proof of the patent should be included. If there's been presentations at conferences, kind of the website information from the conference, the person holding the conference, perhaps the itinerary for the conference that shows the person has spoken, anything that is objective that can kind of back up what's in the expert letters. Evidence of past history of success in the relevant field is particularly important. They really are going to want to see that to show that you're well positioned to advance the endeavor. Entrepreneurs can also include proof of contracts, letters of intent, and startup capital to show the endeavor is likely to succeed. So if you've pitched your business and you've had outside investors that are interested in investing, that's very helpful to show that the endeavor is likely to succeed. All right, so let's look at this case study for entrepreneurs. So we talked about an engineer earlier, so now let's switch to talk about a different kind of entrepreneur. This one was forming a consulting firm to work on projects focused on improving services to U.S. veterans. So when we talk about the substantial merit and national importance, they used expert letters, news and media articles, and research reports. The supporting documents outlined the difficulties faced by returning veterans from Iraq and Afghanistan and showed the value of importance of providing these services. So that's the substantial merit. Letters from experts and leaders in the military, government, business, charitable institutions, and kind of proof of the federal government's own initiatives in this area demonstrated that this is nationally important, and the work that they're doing, meets that national importance and substantial merit. In terms of proving this person was well positioned to advance the endeavor, many of the things mentioned in the first prong were also relevant to the second prong. So the letters from government officials, business and philanthropic leaders, and industry experts talked about this person's prior experience and success in this particular area. Additionally, this entrepreneur included a business plan that outlined what they were going to do and backed it up with objective financial assumptions. Additionally, they had kind of letters from prospective clients wanting to work with them. They had a sound marketing strategy, any kind of, emails and letters, also included. So anything you have showing that people are going to want to use your company, particularly if that's coming from kind of high level or recognizable companies or, government institutions. And then as well, the business plan was able to show that there was startup capital, to help fund the venture, as it kind of got on its feet. Also, on balance, they could show it was beneficial to the U.S. to waive the requirement of the job offer and labor certification. As the owner of the company, it's not possible to get the labor certification. Additionally, the value of the services he planned to provide and the track record of success meant that even if other people were providing these services, the U.S. is still going to benefit from this person's contributions. Okay, so it looks like we have a couple of questions. Someone asked, in the case of an entrepreneur under exceptional ability, what are examples of certifications and memberships that would work? So for this type of criteria, it's going to depend based on what type of field that you're in, but you're looking for certifications and memberships that are kind of awarded based on merit. So if it's a membership where you can kind of, that's given to you based on, well, I worked for 10 years in this field and now I'm paying a monthly fee of $250 or something like that, those are really weaker in terms of the memberships. You really want to look for memberships where you're only able to gain access to them if you have demonstrated accomplishments. Similarly for the certifications, if they're issued by prestigious places, you want to stay away from kind of memberships or certifications that are kind of easy for anyone in the field to get, just by paying a fee. You can also look at who is a member of these organizations. Are these people that are kind of experts in the field? That can also be helpful. So you want to look at kind of what's the criteria for becoming a member to see if it will meet that, exceptional ability. Is this only offered to people who are, above what's ordinarily encountered? So someone has indicated I'm an inventor and work as a product design and development consultant. I have a few patents and 1 governmental rights and a master's degree in engineering. Do I have a chance of getting an NIW? It's really not, the type of thing we can answer in a webinar. I would encourage you to set up a consult with us so we can go through your information in more detail. I think that the start of this sounds good. Certainly, there's areas of this that sound promising, but it's something that we just have to assess in a lot more detail. The startup I'm working on now and will be using for the NIW is going well. The previous startup I worked on did not go well. Could those 5 years be used in calculating my experience? So potentially yes, but it's a bit difficult to think about, do you really want to focus so much on those years when things didn't go well? So if you're the owner of a company, you would usually have kind of other documents, like your second in command at the company might write you a letter. You might have payroll or internal company documents that show kind of what role you held for the company. However, focusing on that company who did not go well, may cut against the NIW argument that you're well positioned to advance the endeavor. So it would be difficult, I think, to use that successfully. So those are all the questions that we have. Thank you so much for joining us. As I mentioned, you will receive, the copy of this PowerPoint as well as our NIW guide, and this recording will also be shared with you. Thank you so much.